Part-8, Federal Legislature. 83. Federal Legislature. There shall be a federal legislature consisting of two houses, to be known as the House of Representatives and the National Assembly, which shall be called as the Federal Parliament. 84. Composition of House of Representatives. The House of Representatives shall consist of a total of 275 members as follows. 165 members to be elected through the first-past post-electoral system, with one being elected from each of 165 election constituencies delimited in Nepal on the basis of population and geographical convenience and specificity. 110 members to be elected through the proportional electoral system, where voters vote for political parties with the whole country being considered as a single election constituency. 2. The federal laws shall provide that in filling candidacy by political parties for the election to the House of Representatives under the proportional electoral system, representation shall be ensured on the basis of a closed list also from women, Dalit, indigenous nationalities, Adivasi Jati, Khas Arya, Madhesi, Tharo, Muslims, and backward regions, on the basis of population. In so, filling candidacy regard shall also be had to geography and regional balance. Explanation. For the purposes of this clause, Khas Arya means Chetri, Brahmin, Takwi, Sannyasi communities, Sannyasi Dasnami communities. In filling candidacy pursuant to clause 2, political parties shall provide for representation of the persons with disabilities as well. Election to the House of Representatives referred to in clause 1 shall be held through secret ballots in accordance with the law. Each citizen of Nepal who has completed the age of 18 years shall have the right to vote in any one election constituency as provided for in the federal law. A person who is qualified pursuant to Article 87 and entitled to vote in an election to the members of the House of Representatives may, subject to the federal law, be a candidate in any election constituency, provided that a person shall not be a candidate in more than one election constituencies at the same time. In case the seat of any member of the House of Representatives falls vacant while its term still remains for more than 6 months, the vacancy shall be fulfilled in the same manner of electoral system as in which such seat was fulfilled. Notwithstanding anything contained elsewhere in this part, at least 1/3 of the total number of members elected from each political party representing in the federal parliament shall be women. In case women are not so elected as to constitute 1/3 of elected members of any political party pursuant to subclause A of clause 1 and subclause E of clause 2 of Article 86, such political party must, in electing members under subclause B of clause 1, so elect that women members constitute at least 1/3 of the total number of members elected to the federal parliament from that body. 9. Election to the House of Representatives and all the matters pertaining thereto shall be provided for in the federal law. 85. Term of House of Representatives. Unless dissolved earlier in accordance with this Constitution, the term of the House of Representatives shall be 5 years. Notwithstanding anything contained in clause 1, the term of the House of Representatives may be extended by a federal act for a period not exceeding 1 year in cases where a proclamation or order of state of emergency is in effect. The term of the House of Representatives extended pursuant to clause 2 shall ipso facto expire upon the expiry of 6 months from the date of revocation of proclamation or order of the state of emergency. Composition of National Assembly and term of office of its members. The National Assembly shall be a permanent house. The National Assembly shall consist of 59 members as follows: 56 elected members consisting of at least 3 women, 1 Dalit, and 1 from persons with disabilities or minorities from each province by an electoral college consisting of members of the Provincial Assembly, chairpersons and vice chairpersons of the rural municipalities, and mayors and deputy members of the municipalities with different weightages of vote by members of the Provincial Assembly, chairpersons and vice chairpersons of the rural municipalities, and mayors and deputy mayors of the municipalities as provided for in the federal law. 3 members consisting of at least 1 woman nominated by the President on the recommendation of the Government of Nepal. 3. The term of office of the members of the National Assembly shall be 6 years. The term of office of 1/3 of the members of the National Assembly shall expire in every 2 years, provided that for the first time after the commencement of this Constitution, arrangements shall be made by drawing lots to retire 1/3 of the members on the expiry of 2 years, another 1/3 on the expiry of 4 years, and the final 1/3 on the expiry of 6 years. And computing the term of office of the members of the National Assembly for the first time after the commencement of this Constitution, the term of office of all members shall be deemed to have commenced on the day on which the first session of the National Assembly is held. Any vacancy of seat in the National Assembly shall be fulfilled for the remainder of the term of office in the same manner of election or nomination as in which the seat of the vacating member was fulfilled. Other matters relating to election, the members of the National Assembly shall be as provided for in the federal law. 87. Qualifications for a member. A person who has the following qualifications shall be eligible to become a member of the federal parliament. One who is citizen of Nepal. One who has completed the age of 25 years for the House of Representatives and of 35 years for the National Assembly. One who has not been convicted of criminal offense involving moral aptitude. One who is not disqualified under any federal law, and one who is not holding any office of profit. For the purpose of this clause, office of profit means any position other than a political position which is to be fulfilled by election or nomination, for which a remuneration or financial benefit is paid out of government fund. 2. No person may be a member of both houses at the same time. In case a person who holds a political office to be fulfilled by way of election, nomination, or appointment is elected or nominated as a member of the federal parliament under this part, his or her office shall ipso facto fall vacant from the day on which he or she takes an oath of office of member of the federal parliament. 88. Oath. Every member of each house of the federal parliament shall be required before taking part for the first time in the meeting of the house or any of its committees to take an oath as provided for in the federal law. 89. Vacation of seat. The seat of a member of the federal parliament shall fall vacant in any of the following circumstances: in case he or she tenders resignation in writing to the speaker or chairperson, in case he or she is no longer qualified or ceases to possess the qualification pursuant to Article 87, in case the term of the House of Representatives or the term of office of the member of the National Assembly expires, in case he or she is absent in 10 consecutive meetings without providing information to the concerned House, in case the political party of which he or she was a member when elected provides notification in accordance with the federal law that he or she has defected from the party, in case he or she dies. 90. Decision as to disqualification of member. In case question arises as to whether any member of the federal parliament is disqualified or has become disqualified pursuant to Article 87, the constitutional bench of the Supreme Court shall finally decide that question. 91. Speaker and Deputy Speaker of House of Representatives. The members of the House of Representatives shall, within 15 days of the date of holding of the first meeting of the House of Representatives, elect a Speaker and a Deputy Speaker from amongst themselves. 2. Election pursuant to Clause 1 shall be so held that there is one woman out of the Speaker and the Deputy Speaker, and the Speaker and the Deputy Speaker of the House of Representatives shall be representatives from different parties, provided that in case there is no representation of more than one party in the House of Representatives, or no candidacy is filled by more than one party in spite of representation, nothing shall prevent the members of the same party from being the Speaker and the Deputy Speaker of the House of Representatives. In case the office of the Speaker or the Deputy Speaker falls vacant, the members of the House of Representatives shall fulfill the vacancy by electing the Speaker or Deputy Speaker from amongst themselves. The Deputy Speaker shall, in the absence of the Speaker, preside over the House of Representatives. In case election to the Speaker and the Deputy Speaker is not held, or in case both the positions fall vacant, the attending member who is by age the seniormost shall preside over the meeting of the House of Representatives. The office of the Speaker or Deputy Speaker of the House of Representatives shall fall vacant in any of the following circumstances: in case he or she ceases to be a member of the House of Representatives, provided that in the event of dissolution of the House of Representatives, the Speaker and the Deputy Speaker of the House of Representatives holding their respective offices shall continue in office until the previous day of the filling of nominations for another election to the House of Representatives. In case he or she tenders resignation in writing, in case a resolution is adopted by a majority of 2/3 of the total number of the then members of the House of Representatives, that is, his or her conduct is not compatible with his or her office. 7. The Deputy Speaker shall preside over a meeting at which deliberations are to be held on a resolution that the conduct of the Speaker of the House of Representatives is not compatible with his or her office. The Speaker of the House of Representatives may take part and vote in the deliberations on such resolution. 92. Chairpersons and Vice Chairperson of National Assembly. The members of the National Assembly shall, within 15 days of the date of holding of its first meeting, elect the Chairperson and the Vice Chairperson of the National Assembly from amongst themselves. Election pursuant to Clause 1 shall be so held that there is one woman out of the Chairman and the Vice Chairman of the National Assembly. In case the office of the chairperson or vice chairperson of the National Assembly falls vacant, the members of the National Assembly shall fulfill the vacancy by electing its chairperson or vice chairperson from amongst themselves. The vice chairperson of the National Assembly shall, in the absence of its chairperson, preside over the National Assembly. In case the election to the chairperson and the vice chairperson of the National Assembly is not held in, or in case both the positions fall vacant, the member who is the seniormost out of the attending members shall preside over the meeting of the National Assembly. The office of the chairperson or vice chairperson of the National Assembly shall fall vacant in any of the following circumstances: in case he or she ceases to be a member of the National Assembly, in case he or she tenders resignation in writing, in case a resolution is adopted by a majority of the votes of the total number of then members of the National Assembly shall that his or her conduct is not compatible with the office. The vice chairperson of the National Assembly shall preside over a meeting at which deliberations are to be held on a resolution that the conduct of the chairperson of the National Assembly is not compatible with his or her office. The chairperson of the National Assembly may take part and vote in the deliberations on such resolution. 93. Summoning and prorogation of session. The President shall summon a session of the Federal Parliament within 30 days of the declaration of final results of the election to the House of Representatives. Thereafter, the President shall from time to time summon sessions of both or either of the houses in accordance with this Constitution, provided that the interval between the two consecutive sessions shall not exceed 6 months. The President may prorogue the sessions of both or either the House of the Federal Parliament, in case during the prorogation or recess of the session of the House of Representatives, 1/4 of the total number of its members submit a requisition in writing that it is appropriate to convene a session or meeting. The President shall specify the date and time for such session or meeting. The House of Representatives shall meet or commence its session at the date and time so specified. 94. Quorum. Except as otherwise provided for in this Constitution, no question or motion shall be presented for a decision in a meeting of either House of the Federal Parliament unless 1/4 of the total number of its members are present. 95. Address by President. The President may address either a meeting of any House or a joint sitting of both Houses of the Federal Parliament and may summon the members of that purpose. Address by President. The President may address either a meeting of any House or joint sitting of both Houses of the Federal Parliament and may summon the members of that for that purpose. The President shall address the first session after election to the House of Representatives and a joint sitting of both Houses of the Federal Parliament after the commencement of the first session of each year. 96. Deputy Prime Minister, Minister of State, and Assistant Minister entitled to take part in both Houses. The Deputy Prime Minister, Minister of State, and Assistant Minister shall be entitled to attend and take part in the proceedings and deliberations of either House of the Federal Parliament or its committees, provided that he or she shall not be entitled to vote in a House or its committee of which he or she is not a member. 97. Constitution of Committees. The House of Representatives and the National Assembly may constitute committees as provided for in the federal law. In case a resolution is adopted by either House demanding that a joint committee of both the Houses be constituted for the purpose of managing the working procedures between the two Houses of the Federal Parliament, resolving disagreement on any bill or for any other specified function, a joint committee thereon shall be constituted. The joint committee shall consist of a maximum of 25 members in the ratio of 5 members from the House of Representatives to 1 member from the National Assembly on the basis of inclusion. 98. Transaction of business in case of vacancy of seat of a member. Either House of the Federal Parliament shall have the power to transact its business notwithstanding any vacancy in the seat of its member. No proceedings of either House of the Federal Parliament shall become invalid even in the case it is subsequently discovered that a person who was not so entitled took part in such proceedings. 99. Voting. Except as otherwise provided for in this Constitution, any motion submitted for decision in either House of the Federal Parliament shall be decided by a majority vote of the members present and voting. The member presiding over the meeting shall not have the right to vote, provided that he or she may exercise the casting vote in case of tie of voters. 100. Provisions relating to vote of confidence and motion of no confidence. Prime Minister may, whenever he or she considers necessary or appropriate to show that he or she has confidence from the House of Representatives, table a motion in the House of Representatives for the vote of confidence. In case the political party which the Prime Minister represents is divided or a political party in coalition government withdraws its support, the Prime Minister shall table a motion in the House of Representatives for a vote of confidence within 30 days. In case a motion tabled pursuant to clause 1 and 2 is not adopted by a majority of the total number of the 10 members of the House of Representatives, the Prime Minister shall be relieved of his or her office. 1/4 of the total member of the then members of the House of Representatives may table a motion of no confidence in writing that the House has no confidence in the Prime Minister, provided that a motion of no confidence shall not be tabled until the first 2 years after the appointment of the Prime Minister and until another 1 year after the date of failure of the motion of no confidence once tabled. A motion of no confidence to be tabled pursuant to clause 4 shall also mention the name of a member proposed for the Prime Minister. In case a motion of no confidence tabled pursuant to clause 4 is adopted by a majority of the total number of the then members of the House of Representatives, the Prime Minister shall be relieved of his or her office. In case the office of Prime Minister falls vacant because of the adoption of a motion of no confidence pursuant to clause 6, the President shall, pursuant to Article 76, appoint as the Prime Minister the member of the House of Representatives proposed pursuant to clause 5. 101. Impeachment. 1/4 of the total number of the then members of the House of Representatives may move a motion of impeachment against the President or Vice President on the ground of serious violation of this Constitution and law. In case the motion is adopted by at least 2/3 majority of the total number of the then members of both houses of the Federal Parliament, he or she shall be relieved of his or her office. 1/4 of the total number of the then members of the House of Representatives may move a motion of impeachment against the Chief Justice of Nepal or Justice of the Supreme Court, member of the Judicial Council, chief or official of a constitutional body, on the ground of his or her failure to fulfill his or her duties of the office because of serious violation of this Constitution and law, incompetence or misconduct, or failure to discharge the duties of the office honestly, or serious violation of the code of conduct. In case the motion is adopted by at least 2/3 majority of the total number of the then members of the House of Representatives, the concerned person shall be relieved of his or her office. There shall be an impeachment recommendation committee in the House of Representatives for the purpose of making recommendation after inquiring into whether or not there exists ground and reason for moving a motion of impeachment against any person referred to in clause 2. The committee referred to in clause 3 shall consist of 11 members of the House of Representatives. In case at least 3 members of the House of Representatives certify and submit that the received information, notice, or complaint is admissible on the ground of serious violation of the Constitution or incompetence or misconduct or failure to discharge the duties of office honestly, or serious violation of the code of conduct by the person relieving of office and impeachment pursuant to clause 2, and the committee referred to in clause 3 makes recommendation upon inquiring into such complaint in accordance with federal law to the House of Representatives for impeachment proceedings, a motion of impeachment may be moved pursuant to clause 2. After the commencement of impeachment proceedings pursuant to clause 2, the Chief Justice of Nepal or the Justice of Supreme Court, the member of the Judicial Council, the chief or official of the constitutional body shall not be allowed to discharge the duties of his or her office pending the settlement of such proceedings. A person who is charged with impeachment pursuant to clause 1 or 2 shall be provided with a reasonable opportunity to defend himself or herself. Nothing shall bar the taking of action on the federal law in relation to the offense, if any committed while in office by the President or Vice President, the Chief Justice of Nepal or Justice of Supreme Court of Nepal, the member of the Judicial Council, the chief or official of the constitutional body which relieved of office upon the adoption of motion of impeachment under this article. A person who is relieved of the office on the adoption of a motion of impeachment pursuant to clause 1 or 2 shall not be entitled to obtain any facility accruing from such office and to be appointed or nominated to any public office in the future. Other matters relating to impeachment shall be as provided in the federal law. 102. Penalty for unauthorized presence or voting. In case a person who has not taken oath pursuant to Article 88 or who is not a member of the Federal Parliament is present or casts vote in the capacity of a member in a meeting of either House of the Federal Parliament or of its committee, the person shall, by order of the person presiding over the meeting, be fined with the sum of 5,000 rupees for each instance of such presence or voting, and such fine shall be recovered as a government due. 103. Privileges. There shall be full freedom of speech in both houses of the Federal Parliament, and no member shall be arrested, detained, or persecuted in any court for anything expressed or any vote cast by him or her in the House. Each House of the Federal Parliament shall, subject to this Constitution, have full power to regulate and decide its internal business, and the concerned House shall have the exclusive right to decide whether or not any of its proceedings is regular or irregular. No question shall be raised in any court in this regard. No comments shall be made about good faith concerning any proceeding of any House of the Federal Parliament, and no publication and broadcasting of any type shall be made about anything said by any member intentionally distorting or misinterpreting the meaning of the speech. The provisions of Clause 1 and 3 shall apply also to persons other than the members of the federal parliament who are entitled to participate in the meetings of the House. No proceedings shall be initiated in any court against any person in respect of the publication under the authority granted by any House of the federal parliament of any document, report, vote, or proceeding. For the purposes of this clause and clauses 1 to 3 and 4, House means the House of Representatives of the National Assembly and includes a joint sitting or committee or joint committee of the federal parliament. No member of the federal parliament shall be arrested during the period from the issuance of a notice summoning the session to its prorogation, provided that nothing in this clause shall be deemed to prevent the arrest under the federal law of any member on a criminal charge. In case any member is so arrested, the authority making such arrest shall forthwith give information thereof to the person proceeding over the consent House. Any breach of the privileges shall be deemed to constitute the contempt of the federal parliament, and the consent House shall have the exclusive right to decide whether or not any privilege has been breached. In case any person is in contempt of any House, the person presiding over the consent House may, after a decision by the House to that effect, admonish one or impose a sentence of imprisonment for a term not exceeding 3 months or of a fine not exceeding 10,000 rupees on such person, and such fine shall be recovered as the government due, provided that in case such person apologizes to the satisfaction of the consent House, the House may pardon, remit, or commute the sentence imposed on him or her. Other matters relating to the privileges of the federal parliament shall be as provided for in the federal law. 104. Procedures relating to conduct of business. Each House of the federal parliament shall frame rules to conduct its business, maintain order during its meetings, and regulate the constitution, functions, and procedures of the committees and procedures of the House or of its committee. Until such rules are framed, the federal parliament shall regulate its procedures on its own. The conduct of business of the joint sitting of the federal parliament and constitution and proceedings of the joint committee of the federal parliament shall be regulated by the rules or procedures approved by the joint sitting of both houses of the federal parliament. 105. Restriction on discussion. No discussion shall be held in either house of the federal parliament or any matters that may cause adverse effect on the dispensation of justice in cases which are sub judice in any court of Nepal and in any judicial act carried out by judges in the court of performance of the duties, provided that nothing in this article shall be deemed to bar the expression of opinions about the conduct of a judge during deliberations held on a motion of impeachment. 106. Secretary General and Secretary of Federal Parliament. The President shall appoint the Secretary General of the House of Representatives on recommendation of both the Speaker of the House of Representatives and the Chairperson of the National Assembly, the Secretary of the House of Representatives on recommendations of the Speaker, and the Secretary of the National Assembly on recommendations of the Chairperson. The qualification, functions, duties, powers, and other conditions of service of the Secretary General of the Federal Parliament, Secretary of the House of Representatives, and Secretary of the National Assembly shall be as provided for in the federal law. Secretariat of Federal Parliament. There shall be a secretary for conducting and managing the business of the Federal Parliament. Establishment of such secretariat and other matters related thereto shall be as provided for in the federal law. Remuneration. The remuneration and facilities of the Speaker and the Deputy Speaker of the House of Representatives, the Chairperson and the Vice Chairperson of the National Assembly, Chairpersons of the committees, and members of the Federal Parliament shall be as provided for in the federal law and shall be as specified by the Government of Nepal until such law is met.